My Lords, first of all, the timetable. I'm pleased to report that nobody on this side of the court envisaged there being any problem with finishing by 1 o'clock tomorrow at the latest.
Good.
What we propose is that, subject to interactions with the court, I finish by in half an hour, and Mr. Flynn is, we think, fairly allowed 2.5 hours, again, subject to interaction. So that would mean you would have 2 hours this afternoon. My Lord, I was distracted by the crane behind your head, my Lord. That would take him to approximately 11 tomorrow, and then there's plenty of scope for short replies from those with the right of reply, and if necessary they can be guillotined if you wanted to finish before 1 o'clock.
Yeah,
but in any event, they would definitely be finished by 1 o'clock.
Metaphorically speaking.
Yes, precisely so. So that's timetable.
Metaphorically guillotined.
The second point that I just wanted to address was somewhat hesitantly, because I don't want to re-engage in a debate because I simply must finish RN2, but two more responses by Lord Justice Snowden. Why should the burden not be upon us to establish definitively that there couldn't conceivably be a way of them dealing with downstream pass-on? Two quick answers additionally to what I put before. The first one is, of course, under the primary legislation and the rules thereunder, it's my learned friends for the proposed class representatives who have the burden of persuading the tribunal that they should have permission to continue the claim. And a key constituent element of obtaining that permission is to demonstrate to the tribunal that they have a requisite methodology and that they can satisfy the Rule 79(1)(b) requirement of common issues. So fundamentally the burden is upon them, and that's why, inter alia, why I say they have the burden on methodology. And secondly, we say it'd be a rather impossible task and disproportionate if instead, at the certification stage, the defendants were to instruct their expert to go out there into the universe of economics and say, we've considered absolutely everything there could conceivably be, and we can tell you now definitively at this early stage that there is no way of doing X.
That would be a prima facie case or something which demonstrated there was a really serious substantiated issue that the methodology was bound to fail.
Maybe, but even that, you see, might have to cover every single conceivable type of methodology. So you could tick off, just for the sake of arguments, the three that appear in this case. You couldn't do it on a simulation methodology. You couldn't do it on a synthetic counter benchmark methodology. You couldn't do it in an econometric methodology. There may be others. And that's disproportionate, especially when the burden is upon them. And by far the more sensible and proportionate and therefore shorter and less costly is for the person upon whom the burden lies generally to obtain permission to come along and say, well, actually, it's not a very high hurdle, but I can overcome it because this is what I propose. So those are the answers. And if you don't mind, I'll quickly move on. Thirdly, you asked me, I suggested that there probably was some evidence in the expert reports that's not in these bundles. And we found it over the short adjournment, and I'll happily send in the reference to these and copies as need be. But my client, Daimler, instructed experts to opine upon the issue of downstream pass-on. And I just read you out a conclusory paragraph from the expert report of Robin Noble and Andrew Grantham dated 22 March 2019, which we filed with our response to the CPO. And the relevant paragraph is 13.61. For these reasons, I do not consider the issues of ... mitigation and pass on, either in terms of whether proposed class members did pass on, or in terms of the financial effect of any mitigation or pass on, can be dealt with on a collective basis. The potential variables are too numerous, and the data requirements too onerous to allow any of these issues to be addressed on a class-wide basis in either UKTC or, for that matter, RHA, in an appropriately practical, efficient and cost-effective manner. Similarly, whilst it may be possible at some level to undertake an analysis which attempts to estimate or approximate ... mitigation or pass on across subgroups within the proposed classes, the variety across the proposed class members still means that, without going into an impractical level of granularity, the approximations are likely to render the analysis too remote from reality so as to make it properly compensatory. So I appreciate there was the report behind that, but that's the conclusory paragraph, and I can have that sent up at the end of the day. So that's what I had to say before turning to the remaining points of RN2. Just to remind you, so what I've dealt with, there were four, we say, methodological flaws. I've dealt with downstream pass-on. I then went on to say that in the transcript, there was an appearance of econometrics suddenly, out of the blue, including on one of the aspects of pass-on. That's the one I read to you. We say it's too woolly and vague and general. It's maybe this, probably that. I could have thought of this. My instinct is the following. Just to be clear, that one was on pass-on. But what happened as regards econometrics on overcharge was slightly different. But we say equally unsatisfactory and equally fails to hit the process test. What happened in overcharge was that in his fourth report, for the first time, Dr. Lillico said that he might be able to use some econometrics as a, quote, cross-check, unquote. And this was how that worked. If you recall, his primary method was simulation, and that's the one that didn't endear itself to the CAT. His secondary method that emerged a bit later was synthetic benchmark, and that one was also rejected by the CAT completely as being not robust enough. So those were the two principal methods. And then in the fourth report, Dr. Lillico said, oh, well, maybe I could do some kind of econometrics as a, quote, cross-check. And if you wanted the reference to that, I won't turn it up, supplementary bundle, tab 17, page 500, at paragraph 2.17. But for the reasons that we give in our skeleton argument at 49A, which again, I won't turn up in the interest of time, we criticise that and we say, how does this work? All you've really said is there's something called econometrics. Actually, you give a whole bunch of reasons why you think econometrics is not suitable for this case. And they double down on this point in their skeleton for today's hearing. In their skeleton for today's hearing at paragraph 95, they say, quote, there are fundamental difficulties for an elaborate regression, unquote. So their case all along at UKTC has been econometrics is not suitable for this case, right? What's suitable is simulation or synthetic benchmarking. That's their case, and they stick with it. So what they did in their fourth report, just before the hearing, was, oh, well, nevertheless, as a tertiary, quote, cross-check, unquote, we might be able to do some econometrics. But what they don't do, and this is all set out in our skeleton at 49A, is explain what's econometrics, what data is it going to use, and critically, how will it function as a cross-check? They don't do any of these things. Instead, they say regression is actually unsuitable, but nevertheless will somehow use it as a cross-check. And what we say is, on any view, that can't satisfy the Microsoft test. Let me move on to the next point then. This is a conceptually distinct point as a criticism under RN2 of the methodology, and it's all about data. Can I show you, please, the transcript, and then I want to go back to a reference that Mr. Thompson gave yesterday in the litigation plan. So this is a discrete, separate point. Data, unsatisfactory, didn't meet Microsoft process. In the transcript, please, you'll find that in supplementary bundle, I think I call it 2, and it's in tab 29.
Yeah.
And if you were pleased to turn in this to page 1151. This is on at the bottom of 1151, where at line 23, where it says Dr. Lillico, he turns to the issue of the data required, and this, my Lord Justice Snowden, is on pass-on downstream generally. Okay, so any kind of pass-on downstream generally, but it also extends, if you look to line 3, it's lines 2 and 3, it's not just second-hand trucks, but also general prices, so it's both types of pass-on. Okay, resale pass-on and supply pass-on. And what Dr. Lillico is saying here is some are going to need data. Some of these questions will need data from claimants. And then he picks it up lower down at line 15. Presumably, he says, you would need to get some disclosure from claimants. And then it's all very unsatisfactory, we say, because if you turn over the page 1153, what he says is you would probably, that's line 1, do X. At line 3, you would maybe do something else. At line 9, you would maybe do something else. At line 18, we hope that you would then do something else. At line 20, maybe you would do something else. At line 21 is another phrase very similar to the one I showed you before when we were talking about resale pass-on just of trucks. Quote, some sort of econometrics, unquote, that's line 21. And then line 23, probably this. Line 24, probably that. Over the page, line 3, probably this. Line 5, probably that. And then he goes on. So first of all, we say that's too woolly and vague. To be fair to him, this is again partly on pass-on, where he hadn't been instructed to address it in his report. So he's doing his best on the hoof. But what we say is that you can't exercise your gatekeeper role vigilantly and diligently if it's to be done like this. Under the CAT guide, paragraph 6.13, which is in the very back of the authorities bundle at tab 74, it says in terms that what you're supposed to do is put forward your expert methodology on common issues at the time that you make your CPO application. But that hadn't happened in this case. So that's why he's saying probably this, maybe that, probably the other. But on data, there is then a fundamental misconception on the part of Dr. Lillico in my respectful submission. What he says at line 9 is, in my line 8 on page 1154, I beg your pardon.
Yeah.
But in my opinion, it would be easy to ask for some data from people. I mean, as I understand it, once pass-through has been demonstrated, there is a burden on those who are claiming to provide disclosure of various sorts in order to allow the defendants to assess perfectly reasonable what mitigating factors there might have been. Line 18, the claimants are going to have to, some of them at least, are going to have to provide an update in order to allow you to estimate it. But yet, where it broke down was, there is no method for doing this in anything that resembles passing the Microsoft test. It was all being done on the hoof. He says he recognises that you have to get this data, but he has no coherent or acceptable method or blueprint for actually getting this data. I'm going to show you what there was in just a moment.
Just before you do that, and I think the point you're just making now has a resonance with the point you were making earlier. And I was just trying to find the paragraph in the judgment of the CAT which addresses this, what you describe as the on-the-hoof approach, and it's paragraph 157. And I think you have to criticise this. You have to say that the CAT erred, because they recognise the force of the points you're making. And it's really the latter half in which the CAT recognises that Dr. Lillico came up with things on the hoof, as it were.
Yes.
Some econometric analysis as a reality check. So he says combined simulation modelling plus regression may suffice. They recognise there's a lot more work to be done. But then they come back to Merrick's not intended to be onerous. Now, is that an error of law on their part, or is that them balancing?
There is an error of law here, because on this question of data, you will recall, and again, and I do repeat this deliberately, I accept entirely that paragraph 118 of process, as endorsed by the Supreme Court in Merrick, is not a statute. But nevertheless, it does say you have to have, and I quote, some evidence of the availability of data, unquote. And that's not an onerous hurdle. You have to have some evidence of the availability of data, not a wholesale absence of data and no coherent, plausible, credible methodology for getting your hands on it. If you're in that latter camp, you don't pass Microsoft process, even though it's not onerous. And in Merrick's, of course, if you recall, it wasn't that there was no data, there was some data. It's what the CAT had said originally was, you haven't shown me evidence of enough data to be able to do that in a robust manner. And the Supreme Court said, no, it's not onerous, but there still has to be some evidence of the availability of data. And what we're about to see in the transcript, so I do criticise, my Lord Justice Green, that second half of 157. That doesn't meet the hurdle, because in this case, there was no evidence, no proper evidence of the availability of data. I'm just about to show you that. And instead, what Dr. Lillico was saying was, well, I recognise there has to be some data, and it'll be easy to get. But that clashes foursquare with what this court said in Gutman. So, for example, at paragraph 62 of Gutman, Lord Justice Green, giving the judgment on behalf of the unanimous court, said, and I quote, the logic behind an opt-out order, that's of course UKTC, the logic behind an opt-out order is that the CR will not have contact with CMs, class members, at any point. And that, of course, is the logic. And if you recall, in that case, the advocate, who happened to be me, was submitting that on the liability question, was saying, well, actually, I do think you should be looking at class members because there are differentiated questions of liability. And that can't be done in aggregate. And the court rejected that. And they said, hang on a minute, that's not the way these opt-outs, top-down aggregate actions work. They are done without reference to the class members.
We didn't say they had to be done. We said they could be done. In some cases, they might use the class for evidence. I mean,
Yes.
It's not, but anyway, yes, I understand.
And I'm glad you make that point, my Lord Justice Green, because what...
Well, I mean, the point really is it's a matter of common sense and logic, isn't it? It's far more difficult to identify, not just to identify the class members of the opt-out class, but those ones from whom you're going to get any useful disclosure.
My Lord,
could take you weeks and months.
Well, if possible, and I'm going to come on to that,
understand
if
that.
possible at all. And you've taken the words essentially out of my mouth, so I can move on, because what Merrick said in the Court of Appeal on this issue of some evidence of the availability of data is at paragraph 50, and I'll simply read it to you. That question ought to be at certification stage to be looked at in terms of what information can be made available at trial. So those words in paragraph 118 have received Court of Appeal endorsement as saying you have to get at least this far. What information can be made available at trial, and the methodology for getting this information...
We absolutely understand the point. I
Right.
understand the logic of it.
So why didn't he do it?
Yeah.
This was the truly elusive...
Cat was right to say, as they did, it was rather nuanced, perhaps overly generous, you would say, description of 157, but they seem to have been of the conclusion that the simulation modelling approach might generate results. If it didn't, they could go cross-check through regression, recognising that there was a lot of work to be done in the future.
And I accept the burden that I have to show you that by reference, because it's not in the reports, I have to show you by reference to the transcript that it didn't meet the hurdle, didn't come to that hurdle. I accept that, and this is what I'm trying to do. So I've read you what he says about how you do need data, and he says he just thought that's the way it would work. So I'm thinking to myself, back then and now, okay, so where's the methodology that you show me that you are going to be able to get at least some data from the class members that you yourself have recognised must be obtained? That's his wording. And the answer is he didn't do it. And this takes me back to what my learned friend Mr. Thompson said yesterday. Let's turn this up again. The litigation plan, you may recall, he showed you this. He said, oh, well, there's a claimant database, if you recall that yesterday. Let's just look at that. Supplementary bundle, tab 18. Which I hope I've got. Just... Yes, I'm reminded by my learned junior, Mr. Raymond, that in the judgment at 153, the judgment below, where we say an error of law arises, is in the last sentence of 153 of the judgment below, where the tribunal said, we consider, particularly in light of the guidance from Eric's SC, Supreme Court, that it would not be appropriate to demand as a condition of certification that the applicant can show the data which is likely to be available. And we accept that you don't have to show all of the data or the actual data, but what it doesn't say, and where it went wrong, is that you do have to show some evidence of the availability of data, and that was Merrick's Court of Appeal at 50 that I just read out. And I'm just want to find supplementary bundle tab 18, which I had misplaced. So this was the litigation plan that we saw yesterday from Mr. Thompson. If you were to turn in tab 18 to page 513, Mr. Thompson said, I will look at paragraph 50 on page 513. There'll be a claimant database. That's the second sentence. But let's just look at the first sentence. The applicant, so that's UKTC, is a special purpose vehicle. It's not anticipated that it either will be able to or required to provide substantial disclosure. So its starting point was no disclosure. Nevertheless, it says, however, the claimant database will invite potential class members to register their claim and upload supporting documents, which will create a potential data pool to support economic analysis, as explained in the administration plan. So this is the key point. Did the methodology stack up for obtaining this data? But there's a number of things to bear in mind. The report that is annexed to this litigation plan is not from the administrator that was appointed. No administrator had been appointed by the time of the CPO. What Mr. Sergai in his evidence acknowledges on behalf of UKTC is that Ankura was just one of a potential number of possible administrators who might be appointed. And that leads on to the second point, which is that there was, in fact, no claimant database at the time of the CPO hearing. So there was nothing to which my learned friend Mr. Thompson could point and say, here's the database, so here are the people who have already read...
Hang on. Sorry. Why, before the grant of a CPO, and people are given the notice that there has been a CPO and then required actually to sign up to the CPO, would you expect there to be a database?
Because it needs to be more than just, trust me, I'm an expert, I will be able to collect some data. That's what this amounts to, because it needs to be credible and plausible in the context of an opt-out where the Court of Appeal has said, in Gutman at para 62 that I just read out, there is unlikely to be any contact at any stage with any of the class members. And so the dichotomy that faced Dr. Lillico on the hoof was, I suddenly acknowledge orally that I have to get some claimant data, but I think I'll just be able to get that. It will be, quote, easy to obtain. And that doesn't cut it.
Sorry, I thought you were making 2 points. One is you were saying that there wasn't actually already a database. And then the question is whether there's a realistic likelihood of creation of a database in an opt-out case by this method.
Yeah, and the two merge in my mind, and I didn't make that sufficiently clear.
Right.
One way in which you could show that it's practical and feasible, one way, is because you've already started to do it, and here are some indicative indications. That's what the RHA did, right? They had.
Yeah, but the RHA is an opt-in,
precisely so.
and
But
they've got a ready-made
precisely so.
cohort of members.
Exactly. But it's all the more important to show a plausible method in an opt-out for getting members from the claimant class members when you don't even know who they are.
Right, but you wouldn't expect them to have actually done it.
Not.
So that put that to one side. The
Some-
question is whether there's a realistic prospect of them being able
agreed.
to do it if granted a CPO.
Yes.
Yeah.
Agreed. And I should have made that clearer. Yes, it would be a method of showing that it's realistic and possible because you've started or you've got some data from some people. But let's see what, in fact, even the non-appointed potential claims administrator was saying in the report that's annexed. Incidentally, these references in para 50 on page 513, they're all the wrong references. It says 4D, 4E and 4M, but it's misnumbering. It should say 3D, 3E and 3M because there is no section 4. But the critical one is actually not even mentioned there. It's G on page 529 under the...
Since I have no idea what the reference is to, I'm not sure it makes any difference to me. Do you want to just...
yes, if you were to go
what
into...
the actual bundle references are that we should be looking for.
Yes, if you wouldn't mind, we're back in supplementary bundle, tab 18, so in mine that's the very end of the first supplementary bundle.
I'm
Now on page 529.
529.
Yeah, so this is an Ancora administration plan, albeit they hadn't been appointed. And this is the one to which reference is made on page 513. So I'm so sorry, I went a bit too quickly there. But the critical thing is, I mean, by all means read any of it, whether it be E, D or M, but the critical one is actually little g on page 529 because it's headed claimant database. But this is where it falls to pieces because what it says is the claimants will create, claims administrator will, if appointed I should add, create a claimant database. And in this database, claimants will register for an account where they can submit information. Next paragraph down, the information captured in the claimant database will effectively be a register of all claimants who have engaged with the claim. Last sentence, the database will also be used to administer communication in a structured way with those who have registered their interest. And then bottom of page 30 under the same heading, claimant database, 3 lines up from the bottom, 3 and 4, a claimant database will be prepared and be ready for use by potential claimants wishing to register a claim. But I stand back and I say, who are these people who are in an opt-out claim, which almost by definition means they've nothing to do, they don't engage? How is it that these people are going to suddenly register and engage and provide sufficient data to be able to run this on-the-hoof economic regression that we just heard about orally at the hearing? I mean, it's layer upon layer of insufficiently meeting the hurdle. And that's why it doesn't work. So that's my penultimate criticism of.
There's a certain chicken and egg about this. If RHA had not been selected, UKTC was selected, then all of RHA's members would have been in the opt-out group and probably been available to provide data.
Well,
There's a certain...
maybe, maybe not, because the process would have been completely different. It would have been, I will one day appoint a claims administrator. That claims administrator will one day come up with some kind of database.
But that's after the CPO's. Once they've got the CPO, you've got an entire class of quite sophisticated customers.
Yes, but that's an unfair hypothetical to put to me, because UKTC has to be assessed on its own merits. UKTC, we say, failed to meet the hurdle methodologically, irrespective of what was going on with RHA.
Yeah, but you don't blind yourself to the fact that actually there is a cohort of, on my lord's hypothesis, claimants who have indicated a willingness to join an opt-in claim and have been told by the CAT actually no, it's an opt-out claim. I mean, why wouldn't those people be at least interested to know? I mean, what the point this is making is that there'll be a reasonable cohort of people who will be interested in what's happening in the claims.
But it's an unreal hypothetical, with respect, my lord, because the RHA wasn't denied. And these people who are in RHA cannot be in the opt-out. Once they're in an opt-in, they cannot be in the opt-out.
This is on the hypothesis that the tribunal had said, no, we're not going to certify RHA, we're going to certify UKTC, just UKTC.
Well, my lord, in that hypothetical, which is not the one that was being dealt with by Dr. Lillico, I say that you have to have something more than just coming along to the court and saying, oh, don't worry, trust me, I'm an expert, I'll be able to collect some data. And indeed...
He's entitled to say, this isn't hypothetical, he's entitled to say, I know that there are out there a large number of truck buyers who happen to be members of the RHA or affiliated in some way of the RHA, who will be told if UKTC is given the CPO and RHA is not. If you want the claim to be pursued, this is the vehicle that's going to be pursuing it, if you pardon the pun, and you'll be in it unless you opt out. Why do you make the assumption that none of those people would be interested in registering on a website, a database, to find out what's happening to the collective claim?
Well, my lord...
I understand you may say that there's no requirement for them to register on the database. I understand that point entirely, because that's the difference between opt-out and opt-in. But as a matter of common sense, the idea that there would be this website created and a database, a claimant database accessed via a public website, and that nobody would express any interest in it or register to receive further information about the progress of the claim from this cohort of potential claimants is pretty extreme, isn't it?
Well, my lord, I can't sensibly deal, in my respectful submission, with a hypothetical which deals with a set of facts that even Dr. Lillico wasn't dealing with. He hasn't said anywhere in his methodology, which is being assessed for his claim, oh, don't worry, because I and my the co-instructed claims administrator recognise that there are some people who are sufficiently engaged, if it's an opt-in, that should that not happen, then those people will become sufficiently engaged in an opt-out. There's a massive difference between an opt-in and an opt-out, including on the basis upon which they get paid out at the end. And so I don't think, it's not a fair assumption, it's not a fair criticism of me, in my respectful submission, to say that I'm entitled to look at what Dr. Lillico was putting forward as his basis for ostensibly collecting data, to say that in some hypothetical that he didn't address and may never happen, there might be some interested people for a completely different type of claim.
I think we got the point about data.
Precisely. So I'm going to round off. I won't even develop the last point. We also criticise that Dr. Lillico, essentially for the same reasons, didn't have a method of taking out of the claim volume of commerce that was no longer applicable. So, for example, for dead people, for defunct companies, and for claims that were taking place in other parts of the court world, we put this forward beforehand, and when you look at the transcript, you can see that it comes down to, this is transcript page 1128. I imagine I could do this, presumably that, probably the other, maybe, would have thought, and various assumptions. So for the same reasons, if you were with me on my criticisms by reference to the other points, my respectful submission is you're likely to be with me on the criticisms of generically the same type. And then that takes me to the end. I respectfully adopt what Mr. Singler said about the judgment of Royal Mail BT, says it's of no particular relevance or to be distinguished in the manners that he gave. And I would hand over to Mr. Hoskins, and he may want to address the court, but he tells me he has, well, I'll leave it to him. I don't believe he has a substantive set of submission, unless I can assist further.
No,
Those are, thank you.
happily for you, sadly for me, Volvo Renault does not wish to make any more submissions.
Yes.
In which case, my lords, it's for me as respondent to both appeals to make some submissions to.
Can we just start, Mr. Flynn?
Yes.
One of the problems with this court is that there's a sort of acoustic void around about where you are. I had this problem before. I'm pretty certain it's not just my hearing, because I could hear everybody else fine, but you relatively quietly spoken, and I suspect we may be having a problem unless you move over very slightly. You don't need to move too far, but
Just compared to Mr. Harris,
Do not adjust your set. Yeah.
didn't say that.
Tell me if I'm now out of
Yeah,
the
that's
void.
fine.
Out of the void, my lord. Yes, so we're the respondents to both appeals, and in the slightly more than a day and a half, you've heard quite a lot about our case from others. And I don't necessarily agree with everything that's been said about it, but I'm not going to take offence and attempt to correct everything that's been said about it. But I don't agree, and try and focus on the points that seem to be of interest to the court. Obviously, we're dealing here with appeals from a detailed and very careful judgment of the tribunal after a full, I realise there may be some criticisms of that, but it was a full 5-day hearing with detailed examination of the economists and full submissions from all interested parties. As I say, we're respondents to both appeals. What I actually, and again, just despite remarks from the bench, I am fairly content to adopt most of what Mr. Singler said about grounds 3 and 4 of the UKTC appeal. He did, in my submission, a pretty thorough job of explaining the tribunal's review of both sets of cases, and of particularly of the merits of Dr. Davis's approach, which has been, in the tribunal's own words, persistently mischaracterised by UKTC, and I will probably have to come back to that. But just in case it is thought that those submissions are in some way, those submissions from Mr. Singler are in some way devalued because he shouldn't have an interest in which respondent he faces. I mean, I would just point out that we did make very similar points in our skeleton, and you will see that paragraph 66 to 74 in relation to ground 3. We made extremely similar points. I just don't propose to weary the court with a repetition of those unless there are points of particular interest to you. We say they're compelling, coming from Mr. Singler, and they echo what we say in our skeleton argument. And the same goes for ground 4, where we part company with Mr. Singler on ground 4 is the suggestion that was made right at the end of his submissions on, I think, what you described as a pragmatic basis, that UKTC should, as it were, be kept on life support pending the outcome of the funding judgment in the Supreme Court, the PACAR appeal. We say that that would really be, not to misuse a well-worn metaphor, that really would be the tail wagging the dog. The Court of Appeal has already noted, and I can provide references should those be needed, that in the event of this coming out the wrong way, as it were, for funders, the RHA's funding arrangements could simply be adjusted to be compatible, and that this is not in practice going to present a practical issue. And I think the court will appreciate that even if these funding arrangements are caught by the DBA regulations, they can be adjusted so as to comply with them. And in the opt-in context, having a DBA agreement is not prohibited by the statute. If I could just remind you of the reference to that.
Why is it any skin off your nose if UKTC remains, as you say, in some distant room on life support? Why? I don't understand why you should be so keen to kick the ladder down over the battlements when you've scrambled over. It
causes some confusion among the class. We want people to sign up to our arrangements.
Yeah, they'll only be getting a notice from you. They won't be getting anything from UKTC. No, UKTC will be only known to probably the interested cohort of lawyers in this room, and not otherwise advertised.
Well, my lord, you might be right about that, but on the other hand, in the trucking community, if there is such a thing, that might not be the case. And if one has to explain to class members that there may be another option depending on the outcome of some Supreme Court judgment, I think that's potentially troubling for them.
Well,
So,
I don't think Mr. Singler's pragmatic solution envisaged any advertisement to the fact that UKTC would in that scenario be kept alive or advertised in some way to the trucking community. It's simply against the possibility, as I understood it, that for some reason your collective proceedings fell over and could not be saved, and that by chance UKTC could, in which case why wouldn't the members of your current constituency be delighted to know that there was a lifeboat for them and be pretty annoyed with you for having drilled some holes in it and pushed it over the edge to mix all my metaphors.
very, very attractive metaphors too. The point I make simply is that this contingency is not going to arise because it is open to the RHA, as has been established by the Court of Appeal, to restructure its arrangements to comply with the DBA regulations should that be found to be necessary, and that this being an opt-in as opposed to an opt-out, that will be sufficient, because under section 47C8, and that's on page 89 of the authorities bundle, a damage-based agreement is unenforceable if it relates to opt-out collective proceedings, but not to opt-in.
But if you're right, then all that's happening is the UKTC's turning the life support off. It's just being delayed by a little bit.
Yeah, yeah.
So why do you care?
Well, I can't put it more highly than I have. There's been confusion a lot along the road, and it's been a long road, as Mr. Thompson has always said. Has also said, it's nearly 5 years since these claims were filed. We're trying to hold a class together in that on a long road. That's my point. I mean, otherwise we have not particularly taken a position on the UKTC application. I mean, we've made no submissions in relation to their economic evidence or anything of the sort. We simply defended our own CPO applications, which, as you appreciate, were heard together but not were joined.
Could I just quickly clarify? My pragmatic solution was actually to make submissions about this when we have the judgment, because at the moment we're all looking at various hypothetical scenarios. I did say that we recognise some sense in the idea being advanced by UKTC, but I'm not actually going as far as to positively advocate a particular solution at this point. It's simply there will be a delay in your lordship's producing a judgment.
No, I understand.
I think we've got that point,
Yeah.
and I think Mr. Harris also made the same point. I mean, the position may be that the Supreme Court judgment comes out before our judgment does, in which case all will be clear, Mr. Flynn.
Yes.
And if you're right, you'll sort it out, whatever you need to sort out, assuming the Supreme Court decides the case in a particular way.
Yeah.
Alternatively, they will decide the case the other way and there won't be a problem.
Yes. But you want us to turn UKTC off before the Supreme Court decision, if we get to give our judgment ahead of it.
Well, my Lord, I heard what Mr. Singler's pragmatic proposal is, that we make submissions at the time of your judgment. But we would say if the appeal is dismissed, then there's no basis for the stay, and that's the principal argument under ground 4. So we don't see why that should be.
We'll try and spend enough time on ground 4, really, Mr. Flynn.
That's enough on that, my Lord, and I wasn't proposing to say more. Perhaps in that case, perhaps I can go back to where we started at the beginning of the hearing, which is the scope of the claim. And again, my Lord Justice Snowden asked, what are relevant trucks? What are these relevant trucks? Well, you'll see from the claim form, and that's on page 116 of the bundle. Relevant truck, if I can take you to the relevant clause. If you look at paragraph 3 of the claim form, it describes the EC settlement decision and the infringement finding, and says that the decision categorises trucks between 6 and 16 tonnes as medium trucks, trucks weighing over 16 tonnes as heavy trucks, and together those are the relevant trucks.
So any truck, whenever created, wherever created, provided it weighs between 6 and 16 tonnes, is a relevant truck. Is that right?
If purchased in the claim period by a haulier, that's the other part of the definition.
Right. So where do I get that from? That sentence just talks about categorising trucks between 6 and 16, but you say there's built into the reference to the EC settlement decision some time restriction as well.
It's the class definition, my Lord, is in paragraph 1. The sorry, I'm having to. No, it's paragraph 5. I apologise. The class definition. So that relates to the purchases of relevant trucks.
Right. So there's two restrictions. One is relevant trucks, and the other is relevant period.
Yeah.
And the relevant period relates to purchase, not to manufacture.
Yes.
So my antique truck or my vintage truck is provided purchased on the second-hand market during the relevant period is in the class. Is that right?
It all also has to be used for road haulage, meaning own account or hire and reward. So it's
excluding lease, because your
purchase and lease.
your class excludes lessees, doesn't it?
it's purchased and leased, or purchased or leased. What we exclude is resellers. So the point is that they are purchased or leased for the purpose of road haulage, which we define or breaks down into hire and reward, or own account. So
So
people
there's
use
three, in fact, there's three interlocking
all
sort of restrictions that you've got to go through before you get into the class. So
all of those things go into it. So that the vintage truck is unlikely to be used for hire and reward. It's probably used for showing at the sort of events one can only imagine.
My lord knows them very well.
regularly out there with your vintage truck. Yeah.
Steam truck.
I had a pre-war Foden in mind, and I realised there was a rhyme there which probably was inappropriate.
What was that?
Not sure I necessarily want to know.
Moving swiftly on.
I shan't pursue that now. So the main point that I wanted to make on that, because this is where the discussion came up, is that the relevant truck does not have to be one that was purchased new in the claim period, which I think was Mullen's original question. It has to be purchased in the claim period, but it doesn't have to be first purchased new. So in the whole of this case, in my submission, the centrality of what's called resale pass-on has been exaggerated. What the claim is looking for, and we'll obviously go through this in detail, is a used truck overcharge, which potentially arises in a number of different ways, not limited to the sale of a new truck from a class member to another class member, which I think is described as the paradigm case. So there being no, as it were, definitional limitation on used trucks having to be first put on the market as a new truck in the claim period, Dr. Davis does not talk actually in terms of resale pass-on. What he's looking for is the used truck overcharge. And I think we've been taken to the relevant parts of his report. We may need to turn them up again. The relevant condition defined by the tribunal is whether the cartel had an impact on the prices of used trucks. And the theory, you'll remember that two possible theories were discussed or laid out in the Royal Mail case. We can go back to that paragraph too. There are two theories down. The one that Dr. Davis favours or thinks that is more plausible is the one that says that higher prices for new trucks will reduce the volume of new truck purchases, and that has a knock-on effect on the supply of used trucks available in the market, which potentially pushes their prices up, possibly with a lag, depending when the cartel effect actually cuts in, as it were. So that's Doctor. I think the references I'd say, I think you have seen them before. First Davis report in tab 10 of the supplementary bundle, paragraph 38, and paragraph 179 of the same report at page 169, I think, are where he sets this out. And assuming I've got the reference right, what he says is, while the EC settlement decision does not extend to the procurement of pre-owned relevant trucks, it seems likely the prices of pre-owned relevant trucks would have been impacted by the cartel, with a consequent impact on the proposed class members, if it is established that there was an overcharge applied to new relevant trucks. And then the mechanism that I've just summarised For example, any increase in price for new relevant trucks would be expected to reduce the demand for new relevant trucks. This in turn will reduce the supply of pre-owned relevant trucks and so likely increase the price of pre-owned relevant trucks, all else equal. And then if one looks at his second report, and that's at page 306 of this bundle.
Two nine four.
294.
Sorry, page
Page 294.
294. Yeah.
So so for some reason my references are not my. Sorry about that. Paragraph 153 of his report.
I think you were right with 306.
306, yeah.
Oh,
Paragraph
paragraph
153.
153 when he's responding to a suggestion that he'd have to look in pre-owned truck prices in studying new truck prices. He says that is not the case, and then he quotes the bit that I've just read out to you, and then he explains a little bit further what that statement means in paragraph 154. As this statement makes clear, my proposed methodology assumes that the supply of pre-owned relevant trucks depends on the volume of new relevant trucks sold in past years, and this impacts the price of pre-owned relevant trucks of a certain age. This relationship is inevitable. Sales of new trucks in prior years is the major source of pre-owned relevant trucks. Notably, this linkage does not presume that new and pre-owned relevant trucks are close demand substitutes, as would be required for the price of new relevant trucks to vary with changes in the price of pre-owned relevant trucks, as Dr. Israel implies, one of the respondents' experts. And then he explains at 155 he hasn't put factors relating to pre-owned trucks in the new relevant trucks regression, because he doesn't. The preliminary assumption is that they do not affect new truck prices. It says that can be tested for in the usual way, in a way familiar to competition economists. So I think what this means is that the idea that the normal case for resale parcel, this is some kind of paradigm of sales within the class. So sale of a new truck sold within the class is not actually what's going to happen in practice. New truck purchases, new trucks may not be sold at all. They may be sold outside the class. And we know that most of the trucks in the class, present numbers, are new trucks. So the paradigm's not holding there. And crucially, in most cases, probably, a sale of a truck is not to a truck user, not to someone in our class, but to an intermediary, some kind of dealer. And the purchase of a used truck, likewise, is from the dealer. So there's some interference, if I can put it that way, in the pricing mechanism between them, which means in turn that the amount that would be deducted from a new truck purchaser's claim, if there is one, on account of resale pass-on, may well not be the same as the overcharge that's suffered by the used truck purchaser, even in the paradigm case. So Yeah, we're dealing with some quite subtle interactions here.
Sorry,
which-
you said, and I wasn't sure whether I heard this right, but you said that most of the trucks in the class are new trucks. I thought the numbers were, you know, there's a big chunk of just new, chunk of just used purchasers of used trucks, and
There-
some people who both buy used trucks and new trucks.
Some of the numbers are on a per truck basis, and some of them are on a class member basis, and that I think makes them sometimes difficult to read.
So when you say so you say most of the trucks in the class are new trucks.
Because there are,
So by definition, most of the class are the purchasers of new trucks, if that's what you just said is right. Is that right?
yes, if you're talking about well, it depends, because there'll be some large fleets in there. So there are some. I haven't got a sort of table of the numbers, but I mean there are some fleets of hundreds of trucks who have signed up to the claim. At the other end, most
Are you trying to suggest to us that the potential conflict between the purchasers of new trucks and the purchasers of used trucks from them is de minimis or doesn't exist?
well, I don't know on the facts, but what I am saying is that is not necessarily even a frequent occurrence in practice, because most sales will be to and from dealers. So most people who have nice fleets of spanking new trucks and trade them in every 2 or 3 years, they will trade them in with a dealer which may be affiliated to the manufacturers, or it may be an independent dealer. They won't be selling each truck to some purchaser of used trucks. That's the point I'm making.
So what are you saying?
But it's still the case, isn't it, that the purchaser of a new truck, whether it's from a dealer or, well, assume it's from a dealer, the essence of the case on overcharge is that the purchaser's paid more than would have been paid but for the cartel.
Yes.
When that truck owner comes to sell the truck, he sells it to a dealer. But what's said is he gets more money for it than he would otherwise have got because of the cartel. And that's the point about resale pass-on, isn't it?
Yes.
Meanwhile, so he wants, as it were, to minimise the extent to which there's been a resale pass-on, because he wants to say, well, actually, I haven't really made more money out of this than I would have done. Whereas by contrast, the purchaser of a used truck, whether it's from a dealer or from another owner, the essence of his claim is that I've been charged more money for this than I should have been.
He's paid more. The point I'm simply making is this is not necessarily in the same transaction or by the same amount.
I understand all of
By
that,
the same
but
amount.
what we're concerned with here really is the issue of conflict of interest.
Yes.
And that's what obviously troubles this court.
That's
really what you've got to grapple with.
The basic point is, as is said against precisely what you said, the left to themselves, the new truck purchaser says, well, I want to maximise my damages, and the mechanism by which they might do that is by arguing contrary things. That's what I understand the way the case is put. What I'm trying to simply say in an introductory way is that they're not facing each other in a kind of transactional way, or in a kind of indeed, it's not really right to call this an indirect purchaser claim, because
Well, it's the same point as presumably, I mean, I don't know, it's so long since I either bought or sold a car, but presumably people still tend to sell their cars to to dealers because they buy the new car from the dealer and they get the
Yes, on an individual basis, and then fleets of cars is the same.
Yeah.
Same with trucks. They may have an arrangement with the manufacturer, or the manufacturer's appointed dealers, or they may go to some independent. They may have, as a lot of them do, complicated buyback arrangements, which may or may not give a kind of guaranteed price for resale within a certain point. And all of these things are going to have to be looked at. I just wanted to establish in the first place that the class is more homogeneous in the sense that our class is a class of hauliers. They're people who are using trucks, whether those trucks are new or used. They're using trucks for their businesses. These are capital assets in their business, which they turn over every now and then if they can. Some of them may not be able to do that very often.
Is your case that there's no conflict at all, or that it is just much less than is presented against you?
It may partly depend what one means by conflict. It is less acute, I would say, than is put against us. And what the RHA is seeking to do is to represent a class of hauliers,
Yes.
and recover for them the actual
Yes.
measure of their loss.
So your case is essentially, even if there is something which might loosely be described as a conflict, it's properly catered for by the RHA's arrangements and the promises that they made to the CAT about separate representation if it should arise.
If it should arise, and if it turns out to be some kind of intractable problem later on, which the CAT didn't expect to happen, and we would also hope to happen. I mean, it depends how sharply one defines things, but this is a class action. It's collective proceedings. In our case, it's brought by a trade association on behalf of members and anyone else. And as you can see, a large portion of those signed up are not, in fact, RHA members. This is done on behalf of the haulage industry as a whole. And as I say, the class is more cohesive rather than less cohesive, in that they're all using the trucks for the same purpose, by and large. That is their business, not their selling.
I mean,
not the selling.
I know hauliers use trucks for their business. I mean, that's almost obvious. It is obvious. I'm struggling with this whole idea that you say that the class is cohesive, and in reality, this is not a potential conflict we need to worry about. I mean, we were shown the draft notice that would go out. I appreciate it's not finalised, but actually the bits that I'm about to put to you are not the subject of debate, I think, between you and the others involved in this draft. But that notice, which is in the second supplemental bundle at a page that I can't read because it's been cut off at the bottom, but I think it may be something like 21. Electronic 21, contains a very specific paragraph dealing with a potential conflict, and it describes a potential conflict, and it says that anybody signing up to this action has to agree to accept the determination of the RHA following expert advice on what is presented as a potential conflict. So I don't understand at the moment, unless that draft has come completely left field and unconnected to your client, why you are now trying to suggest that there's either no conflict or a conflict that is so minimal we don't need to worry about.
Well, I can address the notice in the, because that's cutting text. My submission is not that there is no conflict. If you took one seller of new truck and one seller of a used truck, might they have a disagreement about what the best way of calculating the damages? And I say, well, yes, but the RHA is seeking to represent this class to recover their actual loss, and not all class members will be identically situated or have have identical interests, but those can be resolved, and that is fair and appropriate. The reason for the notice, it's a statutory.
Well, sorry,
requirement.
I'm going to push you on this if I may.
Please.
You say the RHA is seeking to represent the class and can resolve, well, I think what he sort of essentially was saying is that any issues could be resolved in a way that's fair and appropriate, which is sort of what the notice is saying, but the clear understanding or the clear argument against you is that if you're a purchaser of a new truck, you will want to contend that the price of used trucks was as little affected by the cartel as possible, because then you keep the maximum amount of the overcharge on the new truck which you have bought. If you are the purchaser of a used truck, you want to contend that the effect of the cartel has been substantially reflected in the price of the used trucks, because that will mean that you will get the benefit of the damages. And those two do produce opposite results for new truck users and new truck purchasers and used truck purchasers, don't they?
They do put like that. Yes, they do. But we seek to explain this in the skeleton. But I mean, I might as well go straight to the judgment, since your lordship is troubled by the notice.
Well, I'm putting two things. I'm putting to you the case that's been argued against you, that you simply haven't grappled with the existence of a conflict, and it's not reflected in any mechanism that you put forward to address it, other than saying leave it to the RHA to decide how to deal with it.
No, well, ultimately we leave it to the tribunal to decide, but how the RHA presents its case, as you know,
And how the RHA settles the proceedings.
and how the RHA settles the proceedings.
So how does the RHA resolve the conflict when deciding how to settle the proceedings? Deciding how much of any money that might be offered by the manufacturers goes to the owners of the purchasers of new trucks and the purchasers of used trucks.
This will rather depend on what if any settlement offer is made.
Well, let's just assume you get a generic settlement offer, and it's left to you to decide how you allocate it between the purchasers of new trucks and the purchasers of used trucks. How do you do that?
Well, I would think the starting point would be if there had been no trial, but assume at that point there had been a report from Dr. Davis setting out the results of the regression analysis, then that would inform the approach to settlement, because in our view there's nothing surprising about a purchaser of new trucks having to give credit for resale pass on, and if that resale pass on effect is suffered by purchaser of used trucks, nothing surprising about that purchaser receiving the benefits of that finding. So the attempt that Dr. Davis is making is to discover the extent of actual loss among the members of the class, some of which will be new truck purchasers, some of which will be used truck purchasers, and some of which will have done both, and rather a lot of which will have done both. And in my submission, there's nothing wrong with that. And of course, that's what the tribunal found in, and I'm looking particularly at paragraph 246 and following the judgment, which leads on to the notice date. Because again, this is why it is absolutely fundamental to this case. This is an opt-in class. Everyone who opts in already knows the basis on which the RHA is running the case, and particularly the fact that it's representing both new and used purchases on behalf of the industry as a whole. Everyone knows that, and the Rule 81 notice, when it's issued, will, as it were, put the tin lid on it. And
Are we just at the, can you just clarify the procedural stage that we're at? At the moment, there's no order of the CAT.
there's no
It's in
order.
abeyance, we have the judgment.
There's-
And therefore, we don't have a Rule 81 process for approving the notice. That's yet to happen.
that's yet to happen.
And does that happen as part of the approval of the order or subsequently? It's after you've got certification, is it?
It follows from the certification. So what's happened is, I think normally what would happen as a result, if certification is granted, then the next stage is the notice. At least in an opt-in case, we're not that familiar with it.
And it's
And everything was stayed. Of course, everything was stayed
yes.
because of the appeal.
And it's recorded in the judgment at 253 that the RHA has undertaken to have separate lawyers and experts in the event that is it you or the tribunal identifies a concern. How would it be formulated in the Rule 81 notice? Would it be an undertaking by the RHA? Would there be further details than there are set out in paragraph 253? How would it work?
Well, I think what the tribunal is saying is that this can be dealt with as and when it arises, if it arises, and so it would not necessarily need to go into a Rule 81 notice, but it could. I mean, obviously, the reason for the stay and the fact that the notice discussion has simply ground to a halt is because of this appeal, and proceedings have been entirely stayed except for one item of disclosure, and until as it were we hear from your lordship. So the notice is simply a draft which has not been approved by the or reviewed by the tribunal, and as paragraph 248 amongst others makes clear, and the whole of the judgment, and possibly also the very fact that permission to appeal was granted, the tribunal takes this conflict point very seriously. It knows where it has come from, but it wants the point, the fact that the RHA intends to handle it as it does, to be made clear in the notice, and the tribunal has to approve that notice. So we would expect, depending subject to anything that falls from this court in due course, we would expect to be in front of the tribunal, arguing about the terms of the notice, if that couldn't be done on paper, as well as moving forward to trial with a fairly chunky case management conference at an early stage. So
And the tribunal's analysis in 249 was that it was speculation, at least at that point in time, as to whether there was a conflict. They then, I suppose, looking at their logic, 250 was the identification of the hybrid group and the practical unreality, which they say of the alternative solution in 251. Then there is the 252, the high level of commonality, at least at a high level, albeit that it may break down as you go further down the chain.
yes,
And then 253, your offer of separate representation and experts should a conflict arise in due course. And then they cite the guide saying that that can be done in 254, and they could do it by, amongst other things, identifying subclasses and subcategories in 255,
yes.
which they then go on and deal with under Rule 85 from 256 onwards.
Yes, on just a quick word on subclasses, because I think that term is used in two different ways. One is a sort of formal aspect of dividing up the class,
Yes.
the represented class for various purposes within the proceedings. The other, I think, really is the use of the term by Dr. Davis, because I think what he means is for analytical purposes.
Yeah.
I will divide the claimants and the proposed class members and my analysis in six different groups, and those are not necessarily the same subclasses.
No, we understand that.
I suppose the point I was making was really the latter half of 256 and the latter part of 260. The tribunal was saying the CPO is made at a very early stage. As information develops, variations may arise, which the CAT will then keep under review. This is the latter part of 260.
Yes.
So the CAT's position is that as the information comes into court, it will have better sight of
Yes.
how the existence of categories, and that I suppose would then highlight whether there were, and if so, to what extent, conflicts.
Yes. That's right, and in exactly what. And
Can I just pick up on a point that you, we ought to have a break really, but just to pick up one point, slightly different point, Mr. Flynn.
Yes.
I think you said earlier on, explaining one of Dr. Davis's economic theories about all this, is that one effect of the cartel and the overcharge in relation to new trucks is that actually the market for new trucks contracted, which pushed up the price of used trucks.
yes, I think
In the same way, I suppose, as the second-hand car market in this country at present is at a much higher level than it has been, not because of a cartel, but for other economic reasons. It's the same sort of theory, though, isn't it?
it's just the same sort of
Because
idea.
that's not a, so far as used trucks, so far as new trucks purchases and used trucks purchases are concerned, that doesn't give rise to any conflict of interest at all.
No, it isn't. No,
That's just a matter of economic theory and effect.
Yes, that's why I said the sort of focus on resale pass on in this case,
It's
which
only
is
part of the picture.
where the conflict arises, is only part of the picture.
Yeah.
And the used truck regression reflects that point, not the resale pass on.
I just wanted to understand that. Okay,
Yeah.
let's have a break for 5 minutes.
No, it's right.
Yeah, well, okay. You know, I've got my back. I've got.
Yeah, we've got.
Oh, I see. So we can give them out. Yeah, we'll just.
Yeah, typically, yeah, we give them out.
They come and go, don't I just don't think I've got the temperament. Jessica always speaks very well. She's very well, yeah. I work a lot with her. She's fantastic. Not just respect from so far. Yeah. Have you known Jessica for a long while then? Yes. In law school type? The very best ever from me. Yes. Really? Or maybe yes, we thought about that would have been. Did you grow up in a similar area? Yeah, I'm not sure we did actually. I can't remember. We moved really southwest London. Southwest, that's right. I think I might have go there. I got that. My daughter, we live in Hackney. She lots of my friends who are
That's very public spirited of you. Or was it more just to salve your own PTSD?
That's why the notice is.
Yes, that's right.
No, you're fine. I don't think it's plugged in. I hope it's not.
We all plugged in this morning.
Yeah.
One will say Newcastle and the other will say have a reason to talk about.
Just in case. Yeah.
If you're sure like this.
Sticker. I'll go first. I'll say that if you want to take it, okay.
Rewrite this judgment. This is then I recognise as a conflict of review and it's resolved.
on the texture. The operation arises through supply obstruction.
No, well, I could.
No, we're fixing the roof at the moment, never did we previously. We have very so much stuff in the patio, it's got wall tiles, floor tiles.
But it's because it's unfair for the actual exactly.
It may be convenient to stay on the point of, as it were, what happens next. We've already raised the rule 81 notice, and I think it's been suggested by some of my friends on the other side of the courtroom that in effect, having decided to certify the RHA's claim, the matter is now proceeding, as it were, hell for leather for trial, and it will all have to be determined straight away, as it were, in accordance with the approach that Dr. Davis sets out, and so forth. That really is not what is going to happen. We've talked about the Rule 81 notice, which the CAT makes quite clear it intends to scrutinise closely, and that's paragraph 248, which I think we just looked at. The notice has to be approved by the tribunal, and the tribunal would expect the notice to explain their position in easily understood language. And the position is possibly that set out in paragraphs 246 and 247, and I think that will have informed some of the language in the draft to which my attention was being drawn. But that notice is, as it were, at an early stage, all bets are off, and we have to now wait for the judgment of this court.
Can I just ask you about
of course,
246 and 247?
Yeah.
The more difficult part of this part of the judgment is the CAT's conclusion in the last sentence of 247. Such informed consent avoids the RHA and its advisors being placed in a position of conflict, suggesting that mere notice without law obviates the risk of a conflict. And that rather suggests that an expert is able to divide her or his mind as between two potentially conflicted or contrasting positions, a position which the tribunal itself in the RM case found rather difficult to accept in relation to both experts. So if the issue wasn't just notice, but the CAT concluded you had to go further than just notice. The notice had to be properly drafted and approved by the CAT, transparent, setting out all the risks. How much further would you have to go?
Well, my lord, the notice, as I said, sort of puts the tin lid on a state of affairs that is already well known to the class members. I mean, there's lots of detail on the specific website about how the the RHA is intending to, and people have, I can't say opted in yet. They have committed to the proceedings on that basis, and we say that's a crucial factor in understanding the level of.
Is that your end point, or is that the start point? What about 253?
Yeah.
To what extent might the CAT require you to satisfy it? That in the event, I mean, we understand that there may be a dispute as to the extent or nature of the conflict, but assuming one exists, and that a notice in and of itself wasn't sufficient, and the CAT wanted further comfort. Now, you've offered in your reply separate representation and economic analysis. Would that be something which would go into the notice?
I can't see why it shouldn't go in the notice if the tribunal thinks, having heard the parties, that is something that is required to go in now, or that it can be addressed at a later stage, as seems to be the tribunal's.
Well, the CAT might say we want a facility for it, and we also want to make sure that funding is adequate for it.
I mean, it's a bit difficult to say there's informed consent in a real sense, unless the members of the class are told from the outset, as it were, by the notice, this is what we're proposing to do, but if necessary, we will instruct a separate team of lawyers and experts, and what's more, we can assure you that all the funding available will not be affected. And that's really, because then the class members have that assurance, they know what the full picture is, and they know that if need be, on this hypothesis, the CAT will insist on having that separate representation. You may be right in saying, so far as when the actual separate representation occurs, that it may be the defendants are going too far in saying, well, it has to happen now, as opposed to happening in the future. But in terms of the notice, it seems to me at least, that they really, the members of the class have to be told that that's a possibility that the CAT will keep under review from the beginning.
Well, my lord, everyone in the court hears what you say about that, and therefore, when the notice becomes a live issue again, it may be in a judgment, or it may simply be that if I don't mention it, someone else will for me before the CAT.
I doubt it'll be left to Chinese whispers.
It'll be put in the judgment one way or another.
And the statement in paragraph 253 is a pretty firm one, and that's the RHA has said it is willing to commit. And in my submission, it's too early and would be disproportionately expensive to set up that clean team now. But that it can be done, and it will be done should that prove necessary and be required by the CAT as the case develops. And all of this in a context, possibly picking up on a point that I think was raised earlier, I think on the jurisdictional question, is this something which cannot be addressed now, or is it, if there is a problem, can it be, as it were, case managed away by the CAT over the course of the proceedings? And I say, of course, my friends have to say it's the former. I can say that it's the latter. The CAT has extremely wide case management powers, and it's not going to be afraid of using them. And there are plenty of markers in this judgment.
If it's true that the nature and extent of the conflict is uncertain, it will become clearer as time goes on. And then the CAT would be in a position to measure it and decide on what was the proportionate response to it.
Yes, because at some point, and in these proceedings, as I say, it's been a long road. But at some point, if a Rule 81 notice is issued, then there is an end to the opt-in period. And when we have the opt-in period, we will know exactly who's in the class, and we will know the makeup, and whether it's majority new trucks,
yes,
as it stands at the moment, I think it's 20% used trucks. There are various figures floating around. But in terms of class member numbers, it's likely to be the inverse, because it's the smaller, scruffier, if I can say that, people at the bottom end of the used market who have one or two used trucks, and there are a large number of those, which the RHA has always been very concerned to defend and take care of their interests in these proceedings. But of course, it's not only the notice that's got to happen yet. There are pleadings, and our pleading will have to be amended in line with some of the indications from the tribunal in its judgment. It has, as I mentioned earlier briefly, granted disclosure and lifted the stay for the purpose of granting the disclosure of the, I think, the unredacted version of the decision in the Commission's file. I haven't seen that material yet, but if that's likely to lead to some repleading, we will then have defences. We haven't got them at the moment, as my Lord Snowden was establishing earlier. And at that point, the defendants, as they will be there, not respondents, will have to come off the fence and specify what their defences are on.
Are you going to be able to plead in the light of disclosure? Is that the intention? Or will you just plead?
I think we will plead. I think we will have to amend the claim form before we get disclosure. I believe that's the. But again, this is it's in the CAT's case management power to say, well, hold on, you should have that disclosure. But there'll be other disclosure as we go. So it'll be as you know, there's a lot of disclosure or data requirements from the OEMs and from their dealers and possibly third parties, which are going to be needed to inform the regression analysis. So that may or may not translate also to a need to plead, or it may just go straight into the, as it were, into the.
So the procedure, assuming it goes back, it's pleadings, claimants' pleadings, or case methodology might change in the light of the pleadings, but in FX we decided the term pleadings covers everything under the sun. Then defence. At some point disclosure comes in.
Yes.
Then there might be amendments. Then one moves to experts.
Yes, I mean I think at an early stage we'll be trying to get the data necessary for
absolutely, and there may be some process of working with the experts on that.
Yeah. Yes.
At the risk
I
of
beg your pardon.
at the risk of sort of breaking in a little bit to this, can I just go back to what the CAT actually said in relation to this? Can we go back to 246? Of the CAT's judgment at page 322, and just picking it up halfway down the page, halfway down the paragraph where the CAT says here PCMs who acquired new trucks and PCMs who acquired used trucks have the same common interest in seeking to maximise the overcharge claimed on the original sale of trucks by the OEMs. Their interest may then diverge on the quantification of pass-on by resale of the truck, so the CAT identifies a conflict or a divergence of interest.
Yes.
And then it provides a solution, or at least it appears to accept a solution. It says, but as the RHA explained, the position which it adopts on the level of pass-on for the purpose of the action will be governed by the expert advice it receives from Dr. Davies, who will be considering the matter on the data without a predisposition one way or the other. So then they note that Dr. Davies says, I don't understand how PCM's different incentives would in practice affect the practical application of economics and econometrics in these proceedings, so that a subset of PCMs would succeed in influencing the econometric evidence in line my defendant's experts report to the benefit of themselves and the cost to other PCMs. So am I right in thinking that the CAT appeared to accept Dr. Davies' evidence that he can only see one answer to the question? He doesn't accept that his answer could be affected in any way by the fact that he's, as it were, determining, as between two opposed interest groups, what the economic and econometric answer is. He seems to have an incredible faith in the fact that there is only one answer.
I mean, this is his opinion, and he's the expert. No, he wasn't challenged on it, but his opinion is you get the data in and you run the regressions, and it will show you.
So there's no scope for any expert, economic or econometric experts to differ in views. I mean, I'm delighted to hear it in the competition field.
Well,
that experts won't disagree.
Would they have had that right? Would they? I don't see how they could have taken this view if they'd had their own judgment in RM, particularly paragraph 480,
well,
in which the CAT was pretty scathing. Well, 475 onwards, the CAT was pretty scathing of the suggestion that regression analysis could result in anything other than, they put it, spurious accuracy. And, I mean, so regression analysis, as they constantly say, is rests upon the assumptions which are not necessarily statistical.
But
I wonder if they'd had this judgment, they would have made the same point
And
in
then,
paragraph 246.
you see, because then following on, what the CAT says in 247, these are the paragraphs you referred us to, if the RHA explains this in its notice, that basically, and I will quote from the draft notice, which I think is a very fair reflection. I'm not criticising the drafters of this notice. I think it's a very fair reflection at the moment of what the CAT says. Basically, you have to, if you agree to opt in, you agree to accept the determination of the RHA and its expert, following expert advice, as to how the cartel impacted on new and used trucks. So you're basically being told, if you opt in, this conflict will be resolved on a binding basis by an expert against whom there is no appeal, and who thinks that there's only one answer that can't possibly be affected by any differences of
econometric.
Thank you. Analysis. And I find that an extreme view, given the many millions of pounds spent on experts in this type of case.
Well, I mean, let me say two things. One is that is his view, and what he's saying is, if someone whispers in my left ear, favour the new, and someone whispers in my right ear, favour the old, he doesn't know how he could put his thumb on the scales. That's what he's saying, and that's his view. He was not questioned on it. And you may think he's and possibly naive, but that's what he believes. Having laid out his proposed approach, he believes that will show the extent to which, and he's agnostic, to which there is a new truck overcharge, to which the extent to which there is a used truck overcharge, and these are not single numbers but depend on truck characteristics and all that sort of thing. And he thinks that produces an answer, and he doesn't know how he could influence the outcome if you were told, actually you just got to favour the new truck.
Well, it's not a question of favouring. I mean, the answer is, if you said,
Well, I think
if I got two, we all know this from litigation, if you have an expert and you want to differ from him, you instruct another expert who has a different opinion. Now, there may be some issues on which there is a very limited scope for any disagreement upon reputable experts, but in this field, as my lord has indicated, the entirely reputable and competent experts can differ significantly on the inputs to regression analysis and the like. And the difference is that where you have two conflicting groups, they each have, don't they, an entitlement to have somebody with undivided loyalty pushing their case. That's the whole point about how you can't, if you're a single person, serve two masters with conflicting views. It's just putting a single person into an impossible position where he owes duties of loyalty, and for this purpose I'm not talking about an expert who has a duty to the court per se, but certainly RHA, who says they're going to be bound by this, have a very difficult position, don't they? I mean, this is the argument that's put against you. If you've got two conflicting people, you have to recognise that where there is scope for difference, they each have a right to have some separate representation of their interests before a result is arrived at.
At the risk of repeating myself, and I entirely understand the point. And if you were representing, the point I'm trying to make is that these are collective proceedings. We are representing a class. Their primary interest actually is recovery from the cartel.
I've no doubt at all about that. The primary,
cartels.
well, I mean, the count says that. I've no doubt that everybody has an interest in maximising the amount of the overcharge to recover the maximum loss.
And this is not fancy commercial litigation between two banks, or this is a class of mostly small businesses, owner operators, simply trying to get some.
The numbers collectively are enormous. I mean, you're not telling me this is small time litigation. That's looking down the road.
I'm not telling you that. I'm telling you that of course I'm not. But most of the class members are themselves small time, to pick up your to pick up your phrase, and they are looking to the RHA to represent their interests to the best advantage. Now, we cannot, in a class, take everyone on. The whole point of the class proceedings regime is that you do not take every single case and argue it to the nth degree, and we do not, as I think was suggested by Mr. Thompson earlier this week, we do not put to proof. We do not get the new people to put the used people to proof the extent to which they suffered a used truck overcharge. The intention is to, when I say resolve this, it is for the RHA to put forward a coherent position based on Dr. Davis's work, and he does have duties to the court as well, and I'm going to come back to that, to the best of his abilities, which will determine, to the best of his abilities, the actual measure, extent of loss on a per truck basis for each member of the class.
Right, but if that were right and the solution to the conflicts question, which the CAT appears to accept at 247, why did it go on to say what it says in 253, and why did you offer what you offered in 253? I mean,
I think this is all a timing point in respect, isn't it? I mean, the point that Cat's making is Cat's dealing at 247 is whether they're right or not is a different issue, but was there actually a conflict now when the Cat was dealing with it, as opposed to a potential conflict in the future? So what it's dealing with the 253, that sort of area of, is saying, well, there may very well, what may emerge, this is my Lord Justice Green's point, what may emerge after the disclosure at a later stage is that there is, as it were, an acute conflict which requires separate representation. And the RHA has offered that as something that may be required in the future. That's what the CAT has decided. It's not required now. Now, one of the issues we have to decide is whether they were right about that as a matter of case management. Whether we could say, we actually think there is a conflict which requires to be addressed in terms of the notice, and as you've very fairly accepted the notice, there's no reason why the notice shouldn't say, in certain circumstances, it may be necessary to have separate representation if that's what the CAT decides.
Yes. So
that people know from the very beginning that they've got that assurance and that protection. That, it seems to me, would at least potentially address the point about informed consent, but it would also address the point about the RHA, as it were, representing the class as a whole, but hiving off to the extent necessary, which is exactly what, in fact, what the guide contemplates expressly.
And exactly what we offered, and what the CAT is doing here is responding in a number of paragraphs to a whole series of arguments, some of which you have now heard again, possibly most from the appellant. So, you know, this is the CAT's response, having evaluated the matter. I wanted to say that we're not putting forward Dr. Davis as some kind of arbitrator. What we're saying is his expert report will guide the way we put our case in front of the tribunal. That will be contested. The OEMs or the defendants, our particular defendants, will have their experts. They will be able to have a go at Dr. Davis. The tribunal has well-established procedures for evaluating economic evidence. So it's not that this is the answer, it's how the RHA would put forward its case. And it will only do that at a much later stage in the proceedings, if there is a true conflict. I mean, if Dr. Davis may say, I have to hold my hand up, the data not making any sense to me, or, you know, I don't know what he might do. But, so to pick up on a point you made, my lord, earlier, it might be us that says there's a problem. It might be the defendants, and it may be the CAT itself that says there is an issue here, and it's got to be addressed, and it's time to as it were, wheel out the clean team. And I do say it's far too early and disproportionately expensive to start doing that now. But that's what I said to the tribunal, and you know, here we are arguing the point on appeal. So you know, we're in your hands. But I don't see why the notice shouldn't advert to that as a possibility.
There's a difficult issue of incentives for any claimant in your position. There's no great desire to have a differentiated team for obvious reasons. For the CAT, it may take a slightly more broad brush public interest view that for your own protection, your members need to have separate representation. The defendants might do it to increase your costs from a sense of just pleasure and devilment. But it's not necessarily the case that the claimant, and not necessarily you, in theory, will come to court with an interest in protecting the interests of its minority class. The CAT might have to exercise a broader public interest control.
It will be vigilant. I mean, of course it will. But the point on which this conflict is said to turn isn't really, as we explain the skeleton, it's not legally controversial that one has to give credit for resale parcel. No. It's not economically controversial at all. And of course, Dr. Davis would have been criticised for not providing a mechanism, notwithstanding the absence of a pleaded defence. This is routine.
I think the real problem for, I mean, Dr. Davis is a well-known reputable economist, but any economist will at some stage have to factor into the modelling some sorts of assumptions. He may decide my assumptions are X and I'm confident of them. Another economist, equally reputable, might take the view that to protect the minority conflicted class, he wants to push a bit at the assumptions, and that might affect the maths coming out the other end. And the tribunal might ultimately, with the benefit of hindsight, prefer that view. I mean, that's why a conflict can arise with the best will in the world and with the expert acting perfectly reasonably and rationally and properly.
Well, as I say, the defendants will have their experts. The tribunal will have an economist on the panel, and they play an increasingly important role, as is evident in this judgment and many others with which you're familiar. A point I did want to make on Royal Mail. I mean, you you fairly say, my lord, well, you know, the tribunal at the end of the day said, well, regressions are difficult, and you know, ultimately we're going to swing the broad axe here. But I think one has to. I was going to say one has to read the whole judgment. I don't actually recommend that. It's far too long.
Hand on heart, who has?
Even in the piece of your chambers, or whatever the hallowed expression is in the case law. Throughout, and you know, there are important passages in this judgment. The tribunal expresses particular concern with the economic reports on both sides, or some of them, in this case, and you'll be familiar with it. But paragraph 231 of that judgment, which is at page 2016 within tab 46 of that bundle. That starts a section on some general comments on the economic evidence, and I don't intend to read all that out, but it is striking as one has rarely seen a judgment of this nature. Perhaps look at paragraph 235, page 2017. It is perhaps a flaw in the system that in any event appeared quite marked to us in this case that all the experts, but particularly I better read their names, Mr. Harvey and Professor Neville, who opined on a number of different issues, came to conclusions that favoured their clients. And then they say, you know, there's some big and difficult issues on which experts could reasonably disagree. There may not be a single correct answer. Many of them highly technical choices and so forth, all the points we've just been putting to you. Nevertheless, on all those issues, those two experts firmly concluded on the side that produced the outcome in favour of their respective clients. Perhaps that is an inevitable consequence of the adversarial process, and one should expect a party to have an expert in that case. We consider there should have been more recognition on certain issues of the scope for a range of possible results and the reasonableness of the other experts' opinion. And they point out that the primary duty is to the tribunal to assist us in this understanding the factors behind their different conclusions, rather than defending the conclusions which follow their respective clients' positions. And it is full of comments like surprise at a particular expert not being worried by a particular point, undermining credibility from independence, and the overall impression one gets is that the tribunal thought that, as it were, both experts were pushing the envelope to reach a particular position, and in the end, they found the evidence of some assistance, but not, as it were, determinative. So there's plenty more one could read out there, but in my submission, the fact that in this particular case resale pass-on was not proved, and that's section M starts at page 2113. I'm afraid, you know, it's no guide. It's no guide to what might happen in other cases. And
well, the tribunal was critical. I don't know what they said about Mr. Harvey, but the bottom of the end of paragraph 254, in the nicest possible way, they say they were not satisfied that a particular expert was really independent.
yes,
I mean, it's couched in
it's
judicially
yes.
strained language, but that's effectively what's being said.
It's circumspect, and they do say they have no concerns about what had happened since you were an expert, but they are troubled.
Yeah.
And that particular expert is an expert in our proceedings, or has been up to that point. But they are also critical about, so, you know, for different reasons. I mean, this is in the resale pass on, the resale pass on section. At the end of paragraph 546, they say they're surprised that the claimant's expert was not more concerned about a particular problem. And the conclusion on resale pass on, you'll see in 547, DAF and Professor Nevin not established on the facts that the claimant's used truck prices were elevated by the overcharge. Too many unresolved technical and empirical questions surrounding his economics. Now I can't say it. And an insufficiently clear link between the observed facts of this case and the conclusions he draws to meet the test. This impression reinforced by the obvious conflict between the concrete description of the claimant's used truck sales, for example, as provided by Mr. Ashworth, and the abstract nature of Professor Nevin's efforts to measure the effects in question. And what Mr. Ashworth said, you'll see in paragraph 518 to 115. There are two claimants in this proceeding. One is Royal Mail. Royal Mail ran its trucks for around 10 years, or until they were no longer fit for purpose, much longer than most other customers. And the specification for Royal Mail vehicles meant there was a limited resale market for them. And as for BT, during the complexity of the bodies, BT tended to run its LF trucks for 10 to 15 years, at which point they were usually scrapped. No requirement for a contractual buyback in their case. And I think as anyone's driven up the motorway recently, that seems quite plausible. So the idea that there was much value left in these trucks at the end of their economic life, I think spoke to the tribunal, and I would caution against drawing any particular lessons on any score from the way that the economic evidence was handled in the Royal Mail case. As my Lord Justice Green said on, was it only yesterday, and they swung the raw axe, and so they did. But that, in my view, does not and cannot in these proceedings taint the approach that Dr. Davis is intending to take, because the current state of the play is his methodology has been found to pass the gateway threshold, and that's not actually appealed against. What's appealed against is the fact that he's using his proved methodology to determine the used truck overcharge, if any, to be deducted from any new purchasers' new truck overcharge, and that's broadly what that formula that you were showing earlier says. So this has gone on a little from I think where I was going to start, which was not start, but where the point I was about to make was particularly in relation to how the tribunal handles disclosure applications in the ongoing proceedings. And we have thought that it might be helpful, and we have copies which we'll hand up, to see the tribunal's disclosure ruling in all the trucks and direct actions. I think you may have seen that before. Certainly, a large number of my friends have seen it, and it's 2020 Cat 3 is the neutral. So I don't know if somebody could possibly. Thank you. I think my friends have copies of this. been uploaded to the electronic bundle, so the chips are using those, and presumably we'll have the next tab. I know that there's another hand up sort of our proposal, my own friends, I'm afraid I don't know which tab number it is. So, as I say, this is a ruling in a sort of combined case management hearing between three sets of proceedings in front of the tribunal, and its proposed approach to disclosure, and as we'll come to see, it's how it intends to handle them in all trucks cases.
Yeah.
And you'll see that at the end of paragraph 3. Although the disclosure hearing said only 3 actions, it may be expected the tribunal will adopt a broadly similar approach to all damages actions arising from the infringement that come before us. There's no particular reason to think that mutatis mutandis, as it were, this wouldn't apply also to our case. There's a section disclosure to date which we don't need to go through, but you will see that the number of actions the tribunal considers. And paragraph 23, which is on page 9 of this handout, the tribunal begins a discussion of its general approach to disclosure, setting out the tribunal rules, CPR and the tribunal rules over the next few pages. I think that's worth just alighting on paragraph 35, even where cases where broad disclosure is required, it's possible to lay down some broad principles that are applied by the CAT. These are obviously just standard disclosure, non-general disclosure we confine to relevant documents. Relevance is determined by the issues in the case, derived in general by reference to pleadings, that can be in relation to matters not specifically pleaded. Perhaps focus on paragraph 7. Disclosure will only be ordered, and the order will be framed to ensure that it's limited to what is reasonably necessary and proportionate, bearing in mind a number of aspects, including proportionality, costs, usefulness, whether the information can be obtained by alternative means, and so forth. Coming on to summarising that's general principles in the tribunal, then in paragraph 39, trucks, overarching approach in the trucks actions. There's no single right answer in these damages claims. No one can ever know what prices both for new trucks and resale used trucks would have been charged in the absence of infringement. That's a hypothetical world. And it says the President made clear during the hearing, in the case of this nature, it's necessary to consider early on what method or methods will be used to determine issues of causation or quantum, so that disclosure can be tailored accordingly. Now, of course, in the CPO context, that's as it were already happened. We've made Dr. Davis' report sets out in some detail the information that he will require. and this is all in the search of the best truth one can get in the counterfactual world. So in light of that, we set out following broad principles. Burden of proof on the claimant to satisfy that the infringement has effect on prices. If that is passed, the tribunal will seek to provide a reasonable estimate of what the effect might have been and what it can pass on within the relevant legal principles might have been, again, with balance of probabilities. A reasonable estimate means an estimate that's arrived at in a proportionate manner. We recognise these are very large damages claims, but any estimate will still be reached through averages, extrapolations and aggregates. It does not mean that every logical avenue that might be relevant can be explored, and so forth. And at the end of that paragraph, the decision as to what disclosure order is appropriate is informed by the views of the economic experts, but is not determined by what data they would like to have or what method they would like to use. it's for the tribunal to decide. And there's a description at 6 of just how large these cases are. Towards the middle of the paragraph, it's unlikely to be used in these cases, trucks cases, for the issues to be approached by examining how each price charged for each transaction subject to claim and seeking to ascertain how any antecedent exchange of information or coordination between the OEMs may have influenced that price. Similarly, as regards pass on, it would appear to be disproportionate, even if it were possible, to consider the resale or disposal of each truck that is subject to claim. Accordingly, it's important to establish how in practice the issues of trial will be approached, and to do so before and not after vast time and expense is devoted to yet further disclosure. So the approach will be, as it were, expert-led, but not expert-determined. And Dr. Davis, as I said, has indicated in some detail where he is going to be looking for disclosure from the parties, from third-party sources, as well as from class members. None of this was actually challenged. We've not heard any challenge even today, even today or yesterday, in any concrete sense of the kind of decisions that Dr. Davis might be making to inform his experts, his opinion. It simply said, well, there are a whole lot of decisions that have to be taken that might affect them. We can't respond to this in the abstract, if I may say so. We say Dr. Davis's methodology has been scrutinised actually pretty closely by the tribunal, and the OEMs were given the opportunity to respond and comment to that, and that's we say that is now an appropriate methodology, which is proportionate and will lead to an appropriate way of dealing with these issues. A point I would make, I think this shows fairly clearly that even when what is described as individual actions are contemplated, it is hardly the case. The tribunal expects to resolve them by looking at every situation individually in the position of every claimant or every sale of every truck. Averages, extrapolations, and so forth are the way to go. And Dr. Davis's methodology, which Mr. Singler particularly took you to in relation to UKTC's ground 3, does that, we would say, in an ideal and conforming fashion.
Is the purpose of this to show that there's a degree of rounding in both the data collection and in the analysis, which means that as between classes, if they have some sort of a conflict, there's a high degree of aggregation, if you like, using that term in a slightly different sense, which reduces the conflict? Is that the object of this?
I'm simply, I would say yes. Dr. Davis's approach involves averaging, but a search for, as he says, something that's consistent with the data to arrive at the factors that go into his equations.
I suppose, I mean, the bottom line is that one assumes that someone like Dr. Davis will do a thoroughly good job, but does it preclude the possibility that there can be alternative constituents of the modelling which could come out differently as between different class members within the same group? And that's, I suppose, is really the essence of it, assuming he does an extremely good job, as one assumes he will. But there could still be variables in the modelling which lead to different results.
I mean, of course, and I'm not an econometrician, I hazard that word. I mean, I don't know how one can, as it were, twiddle the dials. What Dr. Davis is saying is applying the approach that he outlines, which has been criticised as being ambitious and requiring an awful lot of work.
Yeah.
But as well as data looked at, what he says is this will provide a reliable result, and I don't know. He doesn't know how it can be tweaked. Now, if the defendant's experts on the other side, despite being properly instructed and taking lessons from Royal Mail, can find flaws in what he's saying, then those will have to be argued in the trial, or part of a trial which will come.
I suppose what you can say is that the CAT's approach, which it adopts generally to this sort of litigation, will perhaps reduce the scope for sort of individualised conflicts, because there would be a degree of rounding. But it might highlight, as the evidence and data comes out, that there are groups and subgroups and categories which have to be catered for, and at that point the CAT might identify the need for separate representation.
And that's precisely what it's identified, but at the moment that's unknown.
No, but your position at the moment is premature to form that view.
And who knows what will turn up. But
if there's an issue, it arises with the data as it becomes available.
Then the CAT has tools and
yes,
will in my submission not hesitate to use them.
Yeah.
It will be pressed very hard by the defendants to do so. I mean, they will have their own defined position by then, one assumes. I mean, we know they intend to run resale pass on. We're told that they intend to run downstream pass on, but exactly how or in what detail we will yet find out. But just to say, and these are very different from a series of individual actions where you might get one person saying, hang on, if we take this approach I get another 5,000, or the used truck person gets another 500. So there isn't some kind of sharp distinction between a top-down aggregate damages approach and individual actions. Individual actions, even those which are B2B, not collectors, are clearly going to be managed on,
yes,
I wouldn't say rough and ready, but sampling, aggregating, read across sort of basis. And this is entirely consistent with the approach to compensation which the courts are encouraged to take on the highest authority, doing the best they can with the evidence in front of them, when, as saying, even in a mere disclosure order, the right answer will never be known. So the tribunal was quite clear, for example, that it wasn't relevant as a comment on the practicability of the opt-out, or of the RHA opt-in, or the need for the RHA opt-in, that many of its class members have brought protective proceedings in the High Court. There's a reference to the McCullough proceedings. I think it's referred to a couple of times in the judgment, but 168, I think, is one of them, where again they're talking about this is a point made to the tribunal, 168, page 291, tab 17, and a point made by from Mr. Harris for Daimler on the protective proceedings, and the tribunal says, well, we understand why they've done that, and the page does not remotely mean that a case brought by 14,000 named claimants is an efficient or proportionate manner of proceeding, particularly when it's fundamental to the OEM stance in opposition. Opposition of each claimant has to be considered individually. And then he basically they say that the three I think they're called trial 2, or the second wave of Trucks case claims there, have demonstrated significant challenges in terms of case management and so forth. So they say that individual actions, even for large operators, is not an attractive option. It's entirely appropriate that they be kept within the collective proceedings, handled as you would have seen in the tribunal's judgment and in the disclosure order. Now, with an eye on the time, I've mentioned the independence point and how the tribunal was not assessed in Royal Mail by experts effectively advocating the party's position, and that's why, in my view, the suggestion that Mr. Thompson made that our claim form is in some way conflicted, because it says resale pass on succeeds, I think is the way he put it. We plead, as we're bound to, that there is some harm from the use truck overcharge. Obviously that's going to be subject to proof in the usual way. And as I said, I can't say legally there isn't a conflict in the sense that this is always going to arise. Resale passing would arise. It would arise if we were only representing new truck purchases. We would have to give credit for resale passing, and Dr. Davis would have been criticised if he didn't refer to that and provide a methodology for addressing it. As I've said, even in the absence of a pleaded defence on the point at the moment. So I think the two particular issues that I wanted to raise, and I think that may be tomorrow, but I may not need fully half an hour in which to do that, where someone comments on Canadian jurisprudence, which has been relied on in front of you. I'll do that shortly, and then something on some submissions on further submissions on informed consent and the duties to which the is subject in my submission. So, Lord, if rather than start and break off, I think it might.
That's fine. We'll break for the day and say 10:30 tomorrow.
If that's convenient.
My lord, would you care to give any indication as to the amount of time spent on replies? Because it obviously makes a difference, potential difference to what happens at the bar overnight. There are three parties who were earmarked, or three sets of parties who were earmarked.
How long do you think you need till, Mr. Flynn, in real terms, realistic terms?
Well, my lord, I think I was entitled to another half an hour, but as I've just said, I would hope to be less than that. So, I'll commit to be less than that.
3 minutes. Well, on your original timetable, UK Trucks had 45 minutes. You had 15, and Manandaf had half an hour. So if we 11. 12 o'clock. If you stuck to that, we'd finish by 12:30.
My lord, I'm content with that. I just wanted to draw it to the court's attention.